Tonight, what could the defense be bringing to the table?
Ready to put on our case, which will be more robust than it was last year. So I'm anxious for everyone to learn what we know.
We look ahead to when the team presents its evidence. Plus,
I am not a forensic pathologist. I'm a brain surgeon.
Questions about qualifications after a neurosurgeon takes the stand. Why prior testimony from another medical expert is raising concerns. And our panel answers your questions. Canton Confidential. The Karen Reed murder trial starts now.
We are expecting the prosecution to call one more witness next week before resting its case. And that means the defense will soon be stepping up for the next phase in this trial. Good evening, everyone. I'm J.C. Monahan. Glenn is off tonight. Our Eli Rosenberg walks us through what we could expect from Reed's legal team.
I believe that to be the last one. Okay, that is my understanding.
Karen Reed headed into the holiday weekend.
Does your team plan to call Michael Proctor?
TBD.
Still TBD.
Still TBD.
Just days away from starting to lay out her defense strategy in this, her second trial.
I'm anxious. I'm ready to put on our case, which will be more robust than it was last year. So I'm anxious for everyone to learn what we know.
Could I see counsel at sidebar, please?
This second trial has already proven to be quite different than the first, a trial that ended last July 1st with a hung jury. During that first trial, Reed's legal team spent 2 days on her defense. This time around,
more witnesses, broader and deeper.
They have a lot of tools in their pocket this time that they didn't have around for the first trial.
Reed is accused of hitting her boyfriend, Boston police officer John O'Keefe, with her SUV during a snowstorm in January 2022. Reed has pleaded not guilty to 3 charges, including second-degree murder.
Experts on, the reconstruction, it's the timing that everyone keeps talking about, the autopsy report, all those experts are going to be fair game in the defense's case in chief. Just be interesting to see what order and who they call.
And then there is the lead investigator, former state trooper Michael Proctor, who was terminated by Mass State Police.
No news so far.
After his texts and behavior came out during Reed's first trial. So the question remains right now, if prosecutors don't call him next week, will the defense? Experts say other witnesses that the prosecution called during that first trial could also be fair game this second time around.
Very interesting day to day, even with the long weekend coming up. We'll be interested to see how the prosecution closes its case in chief, but definitely will be interesting nonetheless.
And after a couple of days off, Karen Reed's trial set to resume on Tuesday. Reed did say prosecutors could call as little as one more witness. Judge Cannoni, for her part, says this trial is moving ahead of schedule. Reporting for Canton Confidential, Eli Rosenberg, NBC 10 Boston.
And joining us tonight is defense attorney Morgietta Dourcier, courtroom insider Sue O'Connell, and of course Ronnie Estanislao, who served on the jury during Karen Reed's first trial. Welcome to all of you. Morgietta, we just saw you with Eli. Does that timeline seem right? Prosecution only one more?
Seems about right. One more witness, but it still could be a few days just because it's one person. I think that one person will take the entirety of next week, especially with it being a short week. Maybe one other witness, but I really don't see who else they could call at this point. So I think just the one.
You do? Yeah. Okay. Once again, we're hearing the name Michael Proctor dropped a lot. He's the former Massachusetts state trooper, as you heard, fired in part for his conduct while leading the investigation in the case. Here's an example of the name dropping in this second trial.
And Michael Proctor, as the lead investigator, was the one to write the report, correct?
Michael Proctor wrote that report.
Whose case is it, or who has that case? Your answer would have been Michael Proctor, correct?
Yes. Do you think this case was handled with honor and integrity by Michael Proctor, Sergeant?
The investigation was handled with integrity by Michael Proctor.
That was Yuri Buchanan, who actually answered a lot of the questions that Proctor had answered in the first trial. We don't know if he's going to be called to testify. However, there's plenty of speculation about whether or not he will. And with that, we go to our first viewer question. It comes from Mabel in Scotland. She asks, if Michael Proctor were to be called to testify as a hostile witness for the defense, would that open the door for the prosecution to ask questions about the victim harassment? And in terms of that, we want to play a little sound with what was said recently about harassment in court.
The conversations with Mr. Morrissey, the elected district attorney, what were the circumstances under which you contacted Mr. Morrissey?
Well, during the course of this trial, the witnesses have been harassed.
That's not my question.
Objection.
But I'm answering your question.
Hold on. I'm going to sustain the objection. Next question.
All right, Morgietta, can you tell us a little bit about what a hostile witness is, what that means?
So a hostile witness is a witness that you ask only leading questions, yes or no, meaning that it's different than a direct examination where you ask open-ended questions like who, what, where, why, when. You let the witness go on and tell the story. But a hostile witness, you know you're going in with them not being your friend, right? So you only want them to answer direct answers to your question, yes or no. Now, as you can see in the clip, sometimes they'll try to sneak in an answer or two, and the judge may sustain or strike that portion of the answer, but it's somebody that you know you're going in with fire.
You know, Ronnie, as a former juror, we just played how Proctor's name just keeps getting dropped here and there. What would you make of it if Michael Proctor, that person never materialized and never took the stand?
I think it's suspicious not to have him take the stand since his name has been name dropped everywhere. And it would resonate to me as a juror that he's not being called back.
Yeah, I think that lines up. Let's get to our next viewer question. We're going to keep these going. This is about the prosecution. Tom from Winchester wants to know, why is Hank Brennan prosecuting this case when there are numerous lawyers working for the Norfolk District Attorney? We're going to try to get everyone's take on this because, Morgietta, why? And Sue, I know you follow the numbers, so let's talk about that.
So here's the thing. I think there's no secret that the first trial did not resonate well, not only with the O'Keefe family, but with the district attorney's office in general. And so the district attorney made a decision to hire a special prosecutor. It just so happened to be that Hank Brennan is a former defense attorney or is a defense attorney. And so that sheds a different light on the overall case. I think in general, yes, they have plenty of people in their office that could have done it. But with the stakes so high in such a high profile case, I think it was the right call to get an outside person who has some defense experience to try to do this case in a different light than the first trial was.
I think it makes sense when we're seeing it in court, but like I said, you follow the numbers, aka the dollars, and
right.
Taxpayers are paying for this extra attorney.
So far, $250,000. I'm sure that it will be more. And you know, the other issue is Norfolk County doesn't have a lot of murder cases, right? So there's an issue of expertise. That doesn't mean the lawyers aren't great and they don't know what they're doing, but there is a different issue. And this isn't the only time that this has happened. In the past, there have been counties that have hired special prosecutors to do different things, like go through cold cases and see if they can wrap them up. So we'll have to evaluate when all is said and done and we see what the verdict is. The taxpayers and the voters of Norfolk County will make a decision about whether they or not they thought this was a good idea.
Ronnie, this next question is for you. It's about the many sidebars. We've talked about this a lot. Michelle from Methuen wonders, with there being so many sidebars, what is the jury thinking when they see all of these? So going back to when you were on the first trial and as juror, what did you think every time they asked to stand off to the side and have their little quiet moments?
It was more of making sure that they're following the law and more of making sure they were presenting us with the appropriate information and not being kind of distracted by anything else. So,
but did it sort of, it interrupts the momentum though. And so when you get those as a juror, you have to sort of, don't you have to then focus because you get that start-stop that happens?
I appreciated it because it gave me a moment to kind of say, okay, I can stand up, relax, right? Other than just focusing on so many different things. And it's a barrage of information that you're taking in every day.
That's so true.
And Judge Cannoni is telling them, you know, this is what we're doing. We're late starting because we've been doing business, so you don't have to sit in that box. And I hear from other judges, Judge Cannoni is very, very caring about the feed and care for her jurors. So she's always communicating to them what they're doing and has their time and their patience in mind.
No, and it's nice to hear her explain it. I'm sure as a juror, it's nice to hear what's going on. All right, Morgietta, stand by. Here we go. Next two viewer questions are for you. We want to start with Stacy from Plymouth. She asks, if Karen Reed is found not guilty, will the O'Keefes still be able to pursue the civil case against her? And stemming off that question, we have another viewer, Karen, who asks, who represents Reed in the civil case? Will it be her current team of lawyers? Morgietta?
So civil obviously is different than criminal. The civil case could move forward whether she gets a guilty or not guilty in the criminal case. Now, the criminal case will definitely bolster the civil case, but I think some of the counts in the civil case are completely irrelevant to the criminal case, you know, what's happening here. A lot of it is emotional infliction of distress and, you know, just certain things surrounding what their feelings are overall about the case. So absolutely, the civil case can still move forward independent of the criminal case. It just helps if, you know, unfortunately, not in her favor, but it really doesn't make a difference.
But for both of you who are in the courtroom every day, if you're filing a civil suit, and as you said, a lot of it is emotional distress and what they've been through, are you feeling that the civil suit would have a chance regardless of what the jury comes to in this?
Well, the standards are different, right? It's easier to prove liability in a civil case than it is in a criminal case. So that's going to be the issue. And there are other civil suits moving through here, so that might impact that as well.
All right, let's get to one more question, and this one comes from Sharon in Seekonk. She wonders, what's the legal process for accessing texts specifically from witnesses' phones? Morgietta.
Definitely a subpoena. Everybody has their First Amendment right to privacy. You can't just want to take someone's phone and go through it. You have to have a legal reason to do so, and someone can refuse their cell phone, but you would need a subpoena. The subpoena goes out, and the person can actually object to that subpoena if they have the legal grounds to do so. So it's not just the subpoena goes out and you have to respond. There's a whole hearing that's behind it where you can object to reasons why you don't believe your phone should be investigated, unless it's in part of a criminal case in which the police can just seize it, you know, under constitutional rights.
And you shouldn't give your phone up voluntarily. I know that Jen McCabe gave her phone up, and
she did, yeah.
That was great, except it also had data on there that in the last trial they used to try and catch her daughter in what they thought was some evasiveness on the stand. So if the police or law enforcement ask you to volunteer your phone, say, great, let me call my lawyer first so I can have some things excluded so you're just not going through my phone looking for anything that then the defense or somebody else may use against you.
And nowadays the phone is everything, right?
Yeah.
I'm sure if we asked, you'd all have it on you right now. Morgietta, Ronnie, Sue, don't go anywhere because we'll be answering more viewer questions right after the break. Plus, what seems like a battle of the experts brewing in the courthouse after a doctor was called to testify, why there have been concerns about his qualifications. You're watching Canton Confidential, the Karen Reed murder trial.
Don't miss any of the Karen Reed murder trial. Get the full recap of what happened in court, expert analysis, and what we could see next. This is coverage you won't see anywhere else. Canton Confidential, weeknights at 7 on NBC 10 Boston.
This week, we heard testimony from prosecution witness Dr. Isaac Wolf, a brain surgeon, about John O'Keefe's injuries. He was described by an attorney on our show as one of the most effective prosecution witnesses so far. But as Melody Mendez reports, his testimony raised the question of whether he was qualified.
It was a concern raised by the defense before Dr. Isaac Wolf even took the stand, and then echoed by the defense once he was on the stand.
None of your typical days, none of the past typical months have involved forensic pathology, have they? You haven't acted as a forensic pathologist.
I am. If you could have asked that question, very straightforward. I am not a forensic pathologist. I'm a brain surgeon.
Right. And you don't perform autopsies, correct, sir? You're a brain surgeon.
Correct.
But the Yale-educated surgeon pushed back.
In other words, I see more brains than the forensic pathologist.
Right. And is it correct to say that the brains that you see are of living people?
Correct.
And that is at the heart of the question. On Wednesday's Canton Confidential, attorney Martin Radner drove home the point.
The question here is, JC, does it make a difference whether you see a brain in a live patient or if you see a brain after a person's already passed? That's going to be a question.
But the defense tried to answer that question before it was even asked on day 16 of testimony. So let's go back.
You wouldn't want a specialist, for example, in cardiology without anything more to be conducting a death investigation. Is that correct?
I would not want them to be conducting an autopsy, correct.
Right. Would you want a neurologist to conduct a death investigation?
Personally, or are you asking me that? No.
Under cross-examination by Bob Alessi, Massachusetts medical examiner Dr. Irene Scorti-Bello, who performed the autopsy on John O'Keefe, explained why.
Every physician has their specialty and their training, and forensic pathologists are trained to perform autopsies, and cardiac surgeons are trained to perform cardiac surgery.
Would you want a neurosurgeon to be conducting a death investigation?
To be performing an autopsy? No.
So you wouldn't want a neurosurgeon to perform an autopsy?
No.
Because you don't believe they're qualified to do so, correct?
I don't believe they've had the appropriate training to perform an autopsy.
We asked Karen Reed about it after court Wednesday.
The doctor is not a neuropathologist. He doesn't perform autopsies. So I found him not qualified to speak about what a medical examiner should.
Okay, we are back now with Morgietta, Sue, Ronnie. Let's talk about what was just presented there. I think it's pretty clear what the defense is trying to do. Effective?
Effective, because I don't think that we're discrediting his work ethic. He's a brain surgeon. He said that many, many times. Everybody gets it. The real question is, was his testimony relevant to the charges that Karen Reed is facing? That's what the heart of his testimony really points to, because he does what he does. He's a brain surgeon. But I didn't see the landing point between what he does and the charges that Karen Reed is facing. I just didn't see it.
Ronnie, did you? Because, again, you were in the first trial, so now you have those two conflicting sides.
It did not connect the dots. It's two separate kind of testimonies, and it was very strange why it was being presented by the prosecution.
The biggest problem for me is I wanted to hear from him. In order to get a head injury like that, he needed to be thrust backwards with such velocity, and he didn't need to say only a vehicle could have hit him. But instead what I heard was, I see this a lot in people who are drunk and fall backwards. And so therefore, it didn't connect for me what was happening, what the Commonwealth was alleging happening, versus what the testimony was. Again, I agree, very qualified person. I'd let him operate on me if I needed any brain surgery. I'd fly down to Miami. He'd make me a cappuccino. It would all work out fine. But it just didn't resonate for me.
Okay, let's go to the courtroom setup, because that's prompted a lot of questions since the trial got underway. Lenny asks, are the families allowed to have a certain number of supporters in the gallery with them, or are those extra seats up for grabs each day?
No extra seats. There are 10 seats for each family, and they fill them. And if they don't fill them, if there's 8 one day or 10 the next, nobody from the outside is coming in.
And is that typical?
That's typical because, again, this is one of the smallest courtrooms they have in
America.
Yeah. If you see Ronnie's face, if you're missing, he's like, yeah, it's really small.
You know, and to be honest, I think that was kind of strategic. It's a high-profile case. You don't want a lot of people walking in and out of the courtroom and sitting down. So, but I agree, you do have to limit each side because you can't just have literally a circus inside the courtroom.
No, we don't need that. Let's go to our next question. Mary says, I have noticed Karen Reed texting during the trial, then looking over her shoulder to someone in the gallery on her side, motioning with her phone. Is she allowed to be texting during the trial?
So, yes. But normally, no, not in a lot of trials. Like, even it's very frowned upon even for attorneys to have their cell phones at counsel table because it is distracting. I don't know as a juror if it's distracting to you, but we are sort of prepped to keep our table in a particular way because you're really supposed to be focused on the trial. But again, we know this is a unique case. This is a unique set of circumstances, and Karen Reed is very much invested in her own defense. So I think she's doing strategic work and diligent work and not just trying to...
But she's got the tech person. She's got the tech person behind. Yeah, but what you see on the camera is not what's happening in the room, right? So she's talking to the tech person behind her, and she has law students who are also on her team who are sitting with her family and friends behind her. So many times she's actually coordinating things. Like I see on her screen, there's a piece of photographic evidence that's going to be brought up, and then she coordinates it, and it comes up. And they're all busy, and there's 8 lawyers in there, 8 people. So
it's tight.
Yeah.
All right. We have one more. One of our viewers interested, and we wanted to talk about this, about the people who work at the courthouse. Maria says, there is a court worker with a black thing up to her mouth during trial. What is she doing? What is that black thing? Morgietta, I'll start with you because it does seem a little low-tech for this day and age.
She is the stenographer, one of the official court record-keeping personnel. As you can see in the video, there's also a clock that's running. That's called the FTR system. It runs as long as the clock is running. But what she's doing is literally repeating verbatim what everyone is saying so that later it can be transcribed word for word.
Experts say that's more accurate than typing and shorthand because she's actually saying JC says, defense says, Ron says. So there is a belief that this is a much more accurate way to do it.
Okay, I don't want to be a complete idiot, but why can't we just hit record?
They're doing both. So like I said, the FTR system is running. If you go into any courtroom, you'll see the black box in front of the judge, and the clock is running as long as the numbers are moving. But as Sue said, this is the most effective way because she's also listening, right? So she's another person that says, if someone said this, she's like, no, that's not how I remembered it. I remembered it the way I said it into the microphone.
Interesting. Morgietta, Ronnie, Sue, thank you so much on this Friday. And thank you for all your questions. If you have any, please keep sending them our way. The email is on your screen. Canton.confidential@NBCUNI.com. We'll answer as many as we can. And remember to join us every weeknight at 7 on NBC 10 Boston. We'll have a full recap of the latest developments from court as well as legal analysis. Plus, this week's episodes will be streaming on Peacock beginning Sunday. And if you're traveling for the Memorial Day holiday, be sure to check out our True Crime podcast all about the case. It's basically the audio version of our nightly show that will catch you up on all the twists and turns up until this point.